I think we still have 30 minutes according to the program for the debate. More than 30 minutes, okay, I've been informed that we have more than 30 minutes before the closing session. I don't know if regarding these two presentations, if I already have one question in the audience, so I think there should be a microphone, or if not, I can just give you this one. So there's a first one here in the front, so if
I want first to say that I salute the president of MEDEL, our colleague Philippe César Marques, by this chair of this panel, for this intervention, when he denounced the situation of the public prosecutors and judges that are imprisoned in Turkey, and with his families persecuted, is very important in all meetings of this kind of others to remember this situation intolerable. Second point, I think that in this 70th European Regional Conference of International Association of Prosecutors is also important to remember that in this specific geographic area, Europe, we have winds, political winds, that governments that are menacing the rule of law and the freedom of people. We have, for instance, the Polish government that made a serious offensive against the independence of the judiciary and made a law of retirement some time ago of all of judges of the Constitutional Court. We know nowadays that the appeal to the European Court, European Court was conceded, and they are nowadays in functions. But the idea, the goal of the government of Mr. Kaczynski is the same, and we have serious problems, and in Europe, as I said, that are menacing rule of right and the freedom of people, that are essential principle of that is common ground, I think, necessary of all of us. Third point and the last point that I can say, I want to say here and now. I think that International Association of Prosecutors, that we know that is a wide organization, a very diversified diversified organization, must, notwithstanding, more vocal about these violations and denouncing firmly these violations. Thank you.
So I think there's over there.
Thank you. Good afternoon. I am Judge Hüseyin Cem Eren from Turkey. I work in the Department of Foreign Relations of the Council of Judges and Prosecutors. Firstly, I would like to mention we share the sorrow of our Italian colleague who killed by Mafia Falcone, and we respect his memory here. And secondly, as opening speech, as mentioned at opening speech, I would like to mention three brief things and ask a question to the Mr. Marquez. Firstly, I easily declare that as judges and prosecutors, as Turkish judges and prosecutors, we are on the side of impartial and independent judiciary, of course. As you accept easily, we are not politicians, we are not policymakers. I would like to declare that. Secondly, yes, you are right. We have extraordinary days as Turkish judiciary. Bad days, we mentioned that. But I think some other countries in history or nowadays have some bad experiences. You know why? Because why we are here? We share experience. We reply some questions. We see some good examples, of course, in a friendly way. Extraordinary days of other foreign judiciaries. For example, you can look at lustration process of Eastern European countries. You can look at Italy. You can, for example, Mason Lodge problems. Being in a Mason Lodge as a judge or prosecutor, you can look that. You can look European Court of Human Rights case law also. For example, NF Italy decision. You can see details, or you can see details about lustration in Ivanovsky, Romania decisions. So, as a result, I would like to kindly invite all participants who care, taking detailed information about Turkey and Turkish judiciary, contact with us or almost come visit to us in Ankara and visit our consul and directly ask their question to the member of our council. We are open to share information. We are open to discuss. We are open to share all we have. And additionally, I should say, we have, national judiciaries, and we have part of the Strasbourg court. So if you don't want to take information, if you don't want to visit us, you can see all details in the European Court of Human Rights judgment in 2 years' time. 2 years' time. And additionally, we shared numbers which the President mentioned in his speech with Mr. Han Moral about dismissal, about detention of judges and prosecutors. You can reach, as a result, my question, would you like to consider to come Ankara to talk, to discuss with our council members? Thank you very much.
I don't know if there are any questions apart from this one, who is directed to me.
Yes. You speak in English. In Portuguese, sorry.
I will translate.
Ok. Eu gostaria de saber, uma vez que temos dois sistemas que utilizam a colaboração premiada, a importância que tem no combate à criminalidade económica e à criminalidade organizada nos vossos países, e designadamente nos crimes crimes de colarinho branco, white collar crimes, qual a importância? E depois também, uma vez que temos uma pessoa que também esteve ligada ao combate à máfia em Itália, Maurizio Romanelli, como é que se faz a gestão de um processo, como o chamado processo da Operação Mãos Limpas, com a quantidade enorme de arguidos, de volumes processuais, de número de testemunhas, a quantidade, digamos, gigantesca de processos, portanto, de informação, de tudo mais, como é que se consegue fazer gestão de um processo desses em tempo útil para que os arguidos possam efetivamente ser condenados. Muito obrigado.
I think we could start by answering these first questions, and then we could go for a second round if necessary. I will give the floor to to both speakers, but I would not like to leave the question unanswered. I'm just a moderator. They are the stars of the panel. As MEDEL and other international associations have always said, we are very interested in the Turkish situation. We are very interested in talking about the Turkish situation. Our problem is we need to have someone to talk to. You are from the Foreign Relations Department of the Superior Council? The same Superior Council that the European Judicial Network suspended because they were not independent? The same one that the European Judicial Network said it was not independent from the executive and could no longer guarantee? So, I'm sorry, but I would not like to enter the discussion, so I'll just answer this. Okay. So, okay. Like I said, I'm sorry, I would just like to say, and I understand what you're saying. My answer to this is yes. I would go in the moment we have someone can we speak freely and truly with. That's my answer. I would give the floor to our Italian colleague. Sorry, let's go to the panel.
I'm going to answer to your question, both questions. The first is that our legislation is similar to United States legislation, but not the same. There are important differences, but we studied that system and we tried to organize it respecting our rules. So, for example, but I think you know this aspect, it's not possible for us not to charge a pentito. A pentito who made crimes must be charged with for his responsibilities, and he just can have, and he has a treatment, a good treatment. Sorry for the expression. A good treatment for the conviction, and also for the previous detention in the phase of investigations. But I think that you know that in all countries there are discussions about this kind of instrument. It's not easy to accept these rules, and to accept, to discuss, and to arrive to have an agreement, a sort of agreement with these kind of people. We decided it was necessary, and we tried to have a legislation coherent with the constitutional rules. Maybe, I don't know the list of participants, but maybe you know that in other European countries, in this moment, they are discussing about this kind of legislation. In France, I had 2 meetings, I think, of the School of Magistrates concerning this question, and they have now a legislation. They had, I went to Paris, I think, last year, and they had the first 2 or 3 cases in Marseille, I think, concerning this opportunity. I try to explain in French. It's a little easier for me, our characteristic, the characteristic of our legislation. I think it's possible to have a normal cooperation. If I have I did that. It's incredible. I don't know if I have a minute, but in 2001, in June, before September 2001, I went to United States to have the so-called international visitor program or something just like that. That is the invitation of the American government to magistrate expert of criminality to discuss with them. And I went to New York. That is not in New York. It's the country at the north of the country of New York. No, so no, it's not correct. New York, New Jersey. Okay. And I met there the prosecutor and so on. And I had a significant investigation about ecstasy, because we were arrested in Italy 4 young students, American, of the University of, I don't remember what place, but I think in New Jersey, and they gave us the photograph of the traffic between Holland and United States, because they were just passing through Italy. They were going to United States. And so I had with me, that was an official visit, I had with me the statements of these young people, of these guys, and I carried with me this kind of statements that were really significant. And it was not easy at the beginning to socialize, to share this document, because it's not so easy to have this kind of mutual and timely cooperation. But then we find an agreement with the chief prosecutor of New Jersey, and I gave the statements, and then they did a rogatory, a normal rogatory, and they came to Italy, and they had the statement directly, because this is a rule for the United States, and they could operate in all, not all the states of America, but to rebuild this incredible traffic of ecstasy from Amsterdam. So it's in my opinion, this is an instrument. It's a delicate instrument. We must respect the conditions of every law of every country, but it's possible to have a sharing of this information. Last year we obtained, I say we because I think it's a result also for Italy, the first conviction in Switzerland with the use of the statements of a pentito di mafia, with the reconstruction of, it's called locale, a place of 'ndrangheta in Switzerland. So I think it's possible. I think we should do that with particular attention, because it's not easy to have this kind of information and this kind of relations, but the United States is a leader in this kind of activity. Second question, maybe in the past everybody of us who works makes mistakes, and so I think we made mistakes, but organizing really complex trials against mafiosi, it's really, really difficult, because as you probably know, we have the rules of accusatory system. It's not the complete accusatory system, but we must have trials with the rule of cross-examination of everybody. And so we had trials with, I don't know, it's difficult. It's really difficult. With 100 people in jails, and we had to build the evidence in according to the rules of cross-examination. I want just to say one thing. I had a a woman pentita di mafia, a young woman, and she spoke against her mother, because her mother were a significant person in Ndrangheta. That's an incredible thing, but it's possible. It's possible. And you can imagine what it happened during the trial. She had to see in the eyes her mother and to see what her mother did. And her mother led a part of the organization, and that he decided a certain quantity of murders. But these are the rules. It's difficult. You must be well organized. In the 90s, it was not easy because the informatics was not at the actual level. But I think, and this is, sorry, just one moment. This was the reason of killing Falcone, because Falcone, with the past rules, with the inquisitory system, but he conducted to the court of Palermo i mafiosi, and he obtained to have Tommaso Buscetta and two other pentiti to talk about mafia, to say in a public way, mafia exists. These are the rules. This is what we decide and how we decide. And so that was incredible for mafia, because the first characteristic of mafia group is the secrecy. And so we not me, but we violated the rule of the secrecy, okay? And this was not possible for mafia. And then, as you know, we had a great cooperation with the United States, and to share this kind of method working in the United States against the mafia group being there, that are not so significant, but they are significant. So I hope I answered your question.
Let's see if I can jump in here. My understanding of your question was, cases are huge. How do you organize it? Yet at the same time, protect of the accused. Is that basically what the question was? Well, because that's the question I'm going to answer. When I was a prosecutor, we tried possibly the biggest gang case in LA. It was 13 murders, probably 23 different crimes. They were armored car robberies. And so the logistics of that was huge. And so we're talking about some serious, and it was gang cases, so you're talking about some serious criminals here. We had hundreds and hundreds and hundreds, thousands of pages of police reports. We ran wiretaps in that case. There was videos. It covered beyond LA County. We brought in cases from San Bernardino County and Orange County. There were at least 6 or 7 different agencies involved. There were ballistics that crossed different crime scenes. It was extremely complicated. Now, most of the heavy lifting, right, of putting together the investigation is done by, and I'm talking based upon my experience in my county, in my state. I can't speak to New Jersey. I can't speak to Mississippi. And I don't want to speak to Mississippi. But for my county and my state, most of the heavy lifting is done beforehand by the investigating agency, which is independent of the prosecuting agency. There are cases the prosecuting agency will lead the investigation, welfare fraud, political fraud, things like that. But in terms of violent crime, that is handled by the local law enforcement agency. In my case, when I was talking about, it was lead investigators with the Long Beach Police Department, the Los Angeles Police Department, the LA Sheriff's Department were the big three. There was also San Bernardino Sheriff's got involved, California Highway Patrol was involved. So a number of those dozens of agencies that I put up there were involved. But they do the heavy lifting. They're the ones who are doing the interviews of the witnesses. They're the ones who are going to the crime scenes, collecting the evidence, and so on. And all that's done really before the arrests. The first instance of a prosecutor getting involved in the case will either be to supervise the preparation of a search warrant which doesn't happen very much, the supervision. Most peace officers will prepare search warrants to present to judges. DAs, the prosecutors, generally don't get involved, but we are available. Well, when I was DA, we were available and on call for that, and depending on the case, prosecutors can be brought into the process to make sure that the warrant is written in such a way that later on the evidence will in fact see the light of day in court and won't be suppressed based upon an error in the writing of the warrant. That's where the DAs first get involved. And the second area, and this is where I first got involved, is we ran electronic surveillance on a number of these characters. And that means that a prosecutor has to get involved, has to review the paperwork done by the law enforcement agency, and then present that paperwork to the judge with the law enforcement agency so the judge can make a determination whether or not the legal requirements for conducting an electronic surveillance have been met. Okay, so now we got all this evidence, right? Now you got to balance off two things now too. You got to balance off the fact that these people are criminals and can go out and commit more crimes versus the fact that if you snag them up too soon and you don't have all the investigation done, then you might not have a case to present against them. So that's something that law enforcement balances. Fortunately, because most of the people are criminals, you can always find a reason to arrest them. So if you find something from the wiretap that they're going to go kill somebody, you can arrest them for something else and take them off the street and thwart that. Through the wiretap, found out that somebody they were going to kill was me. But fortunately, they were already in custody at that point. There was 2 lawyers on the case, and they were going to pay, I think it was, I don't know, $20,000 to kill some witnesses and the lawyers. I figured they were going to pay $19,000 for the witnesses and another $500 for the other lawyer, and they'll just throw me in for free. So then the case gets brought. Now then, in the American system of justice, and I'm going to speak again about California, they have speedy trial rights. When somebody's arrested for a felony, within 10 court days of that arrest, a person's entitled to preliminary hearing if they want it. Preliminary hearing is a situation where basically evidence is presented, hearsay evidence can be presented. That is, a police officer can take a statement from somebody and then tell the magistrate what that person said. That magistrate then will decide, based on the evidence that's presented, whether or not there's sufficient evidence for the case to go to trial. The defense in those proceedings can cross-examine both the police officer and, if there are live witnesses, cross-examine the live witnesses. In violent crimes, generally, you want to have live witnesses testify because then you can memorialize their testimony under oath so that if, God forbid, something happens to them down the road, you now have their testimony that you can use in court. If a police officer testifies to a statement, that statement will never, I mean, there's an exception to almost every rule, but that statement will never see the light of day in court because it's hearsay and it won't come in. So you've got to get that witness in a violent crime at a preliminary hearing. They have a right to that within 10 court days, but they also have a right to discovery. And those are the conflicting rights that the defense has. Do they want to go to the preliminary hearing unprepared, or do they want to go to the preliminary hearing prepared? Now, when I was a prosecutor, I would think, just go to the preliminary hearing, get it over with, because we're not going to be ready to proceed. But for some reason, the defense tends to want to get all the discovery, and that allows the case to age and allows all the organization to take place and allows for both the defense rights to discovery and the right to the speedy trial because they can waive and give up that right. After the preliminary hearing, they're held to answer. There's a new charging document called information in California, and then they have 60 days by which the case has to go to trial. Again, generally the defense is going to waive that right to 60 days until they feel they're prepared to go to trial. So I guess to answer the question, it's going to be a balance. Does the defense feel that they can push the case to trial with what they have, or do they want to be prepared for trial and proceed with all the arrows in their quiver? Throw in the other factor that, for the most part, crimes are committed because, well, it's for financial gain or passion. But whatever way it is, most of the criminals don't have money. Certainly not enough to afford somebody of my caliber. So that's supposed to be a joke. But what they get, of course, is the public defender, a court-appointed lawyer. Those people are underpaid and overworked. I would never want to do the job they do. And because everybody has their own lawyer, he's going to have a public defender. That public defender is going to have trial after trial after trial, and they can't do 2 trials at once. So that means that the person who's been accused is going to have to wait until their lawyer is ready to try the case. So again, on a complicated case that doesn't involve a lot of money, there's going to be that wait. And if it involves a lot of money, chances are the person is a financial crime, that they're out on bail, and they're in no hurry to get their case to trial either. Okay? So those are the main areas, I think, addressing your issue of the, if that is your issue, of the conflict between a complicated case and efficient resolution of that case. You know, we'll try no case before its time, I guess, is the bottom line. Thank you.
Before going to the second round of questions, if they are, being this a regional conference, and as we have heard, Italy was one of the first states to introduce laws on cooperation of witnesses and what we could call in a limited way a sort of plea bargain. Out of your experience in investigating and prosecuting these organized crime cases, would you feel it possible to investigate them and prosecute them without some kind of, let's call it plea bargain or other pre-mediated collaboration, as we tend to call it here or in Brazil? How important is this for this kind of crimes to be prosecuted and investigated?
If I'm understanding your question correctly, well, I'm not. Are you saying should we strike deals with criminals in order to turn them over against other criminals?
Exactly. How important is that, and how effective is that in your system? Because it's a big debate going on in some European countries if we should approve a system like that or not.
I think, you know, every crime has its own unique facts, right? So obviously you're going to look at it based upon the crime that you have. In our gang crimes, you know, oftentimes they're done without witnesses, right? It's a drive-by shooting. The only people who witness it are going to be the people in the car, the shooter and the driver. So then you're going to make a decision, you know, how are you going to prove the case? Do you flip the shooter or you flip the driver? Usually you flip the driver, you have a plea bargain with the driver, and they'll get a significant sentence, but, you know, they're not looking at life without parole or life. And again, it's a case-by-case basis. In this armored car case, there were 4 main defendants, and one of them flipped early. He was arrested on some other murder. He flipped early and was a fountain of information concerning all the other crimes that this gang was committing. Now, he did get life without parole, or it might have just been, you know, 4 life sentences, which is the equivalent. But the other 3 all went to trial, and we got the death penalty on them. So you do, I don't think you can have a just result for the victim without sometimes having to not necessarily have a just result for one of the perpetrators. Would that answer your question?
Okay. Because of flight constraints, if you have any other questions, we could go for a second round, especially if some of you want to ask questions to our Italian colleague. He has to go in 5 or 10 minutes because of his flight, so please feel free if there are any other questions in the room.
I think I see, is that the international sign for cut?
Yeah. So if not, thank you once again. It was really interesting hearing you. Thank you all. Thanks again for the invitation, and we'll close here. And I think the closing session will be immediately after. Okay, so we'll head up for the closing session. Thank you very much.